Hello everyone, my name is Marcelo Pichero de Silveira. I am a professor here in Brazil and in my channel, Resenha Forense, and I would like to move on my own brief course of Philosophy of Law, em português, pequeno curso de Filosofia do Direito, translated to English by a friend, Renan de Oliveira Sousa, and I appreciate it that he accepted to do that. Renan, thank you very much again. Uh, well, this is the second meeting, okay, meeting two, called the indispensability of law, okay? So let's move on, and if you are interested in our uh, paper, in our PDF, in our written part, you can click here downside in a link that will lead you to the archive, okay, the PDF with our paper, okay, our meetings in a paper, okay. Importance of philosophy of law. uh, Before we move on, I would like to ask sorry because my English is not that good. I am training, so sorry if I make some mistake here, okay. Okay, let's go. Importance of the philosophy of law. The reality of facts ontology is one. The wind outside, the flow of the sea current, the fall of a tree branch, the ripening of the fruit, the nidation, and so on. They are just examples of how the reality, gigantic as it is impossible to be comprehended by human being without divisions, analysis, and abstractions. Abstractions, sorry. The law, as a social fact as it is, it's a juridical or legal phenomenon, and like that, it is one phenomenon. Yes, the social reality is unique, but they always show themselves by many complex aspects under the manifestation of many different ways. A penalist is worried about the criminal aspect, penalty theory, crime theory, for example. A civilist will try to comprehend, for example, a contract, his origin and his effects. Proceduralists have glimpses about the legal structures and procedural relations, and so on. There is a decomposition of law in particular objects without destroying the idea that he is one object. The theory of juridical fact, so well developed by a Brazilian called Francisco Cavalcante Pontes de Miranda, is one example. A flood in a city is irrelevant to the law system. It can, whoever, feel factual support of the procedural rule who suspend the realization of an audience because the forum was flooded. It can equally feel the factual support of the civil responsibilization of the state for not undertake correct diligences on the sewerage system, and so on. The first case, court hearing suspension, will interest to the procedurist. The second case, civil responsibility of the state, can be interesting for a civilist or for a administrativist, and so on. Sorry about that. What the philosophy of law remember us is that even with a multiplicity of the juridical fields, the juridical reality is just one. It is profound and substantial. Besides that, it can be affirmed that the law corresponds to a fundamental requirement of human essence, even even if certain communist theories claim otherwise, the law it is unquestionable necessity. A Brazilian jurist, Marcos Bernardes de Mello, writes that the Marxism is founded in the ultimate analysis on a fiction that disappearance of the class struggle by the communists would have, as a result, generate a negligible, sorry about that, law in the state. The here's, sorry, the historical truth, however, frustrates and hopes that human society could overcome the instruments of the social adaptation, especially the law. Miguel Reale, another Brazilian, also has written severe critiques to the Marxist materialism, the phenomenological wealth of the Lebenswelt, Germany world, is for him used to criticize historical materialism of Karl Marx and his pretension of searching a juridical priori who just have internal theoretical consistency and do not explain the legal phenomenon generally, but explain it in central ideological assumptions, just a struggle of class. The first category we can read on Miguel Reale. The first category of problems who, in my view, receive a more suitable treatment by virtue of understanding of law as experience refers primarily to the so-called functionality or interdependence relations in which are found the juridical experience with the other forms of social experience. The placement, for example, of the relations between the law and the economy in terms of experience allows the analysis of the matter according to your perspectives and implications without being reduced to many no interpretations by reductionist type as like thought Marx's way, between the infrastructure and the superstructures and one-sided consequence of your historical comprehension. Well, further, Miguel Reale says, the phenomenological comprehension, or as I prefer to say, ontognosological, are at the same time who allows the integral reception of data of the real, recognizing the a priori material who conditionates the cognizant act, prevents the reduction of the culture objectification to a mere phenomenon of infrastructure or economy natural, for example, as like pretends the historical materialism. Moving on, the critics also reach to so-called anarcho-capitalism. If the libertarians dreamed about the impossible dream of a world without a state, they will have to submit to a deontic scale. Okay? The libertarian philosophy preaches justly a minimal ethical where any sort of violence cannot be practiced against a non-aggressor. It is what they call the principle of non-aggression, or just PNA. The libertarian opposes itself not only to the interference of the government in the private property, but also to every kind of attack to private property. We have here a proposition that can be considered as a naturalist. From a natural law perspective, okay? But not Thomist. Finally, the law could not be philosophical object. He cannot be an object of philosophical studies if he was something precarious, susceptible to non-existence. The law necessarily exists. He cannot cease his existence. Because of that, he can and must be studied philosophically, holding a title of philosophy of law. Our further meetings certainly will be insufficient to develop all the aspects of the philosophy of law. It is because of that I decided to focus on the aspects that I consider extremely important. First of all, legal gnoseology. Second, legal axiology. And 31, legal phenomenology. Who search here content for professional activities will not be successful, okay? The philosophy of law does not offer, as a rule, immediate practical or forensic utility. But do not constrain yourself with the immediacy or utilitarianism of any kind. For the 5-year class of law from University of São Paulo here in Brazil in 1944, Miguel Reale said the following words recorded by Fernando Gentili, alerting his students already bored with the course. He said, "Those who search in law college just the forensic knowledge, who sees college only as an instrument to, only as an instrument for professional activities, will have problems with his study, as the philosophy of law does not have any immediate forensic utility and don't even are his area. But the laws, let me erase here, but the laws college does not just exist for immediate and everyday use. They have a culture function. 2 categories of jurists exist, ones who create and others who repeat. The first ones are those with profound philosophical knowledge of juridical science. But do not fool yourselves. Do not exist any relevant modifications on the legal systems which do not have a reason for being remote, who does not have an explanation of nature eminently philosophical." Next point in our notebook here, our book, changes in positive law and philosophy of law. An undoubtful proof of the lesson of the previous class in the modification that the positive law suffers every year. Every modification has a deep explanation and it will be philosophic. So the so-called orality of the process of the procedure, maybe, for example, would be result of a philosophical critical analysis of the concept of action and the analysis of the juridical procedural relationship. The action, ceasing to be an exercise of subjective law, has adopted a new face, who is an autonomous existence, and then emerged a renewed procedural dogmatic. Because of that, an affirmative that philosophy of law works as the vanguard of the study of law is valid. The philosophers of law cut down the trees, and on that clean floor build the buildings of positive law. This explains, in my opinion, why a law student from Brazil will have more facility in the study the law in Portugal, because not only they have the same origin, but also have the same basis. A Brazilian student of philosophy will face more difficulties when studying in Portugal, but not because he is in Portugal, but because he never studied law. Next point. 2 questions. What is philosophy of law? What is your space? It can look simple to show that philosophy of law, because it is from law, is a study of law. The scientific study covers, in the essence, the dogmatics. But the philosophical study of law means to examine it from a speculative point of view. Michel Villet, French, brings an interesting questioning who resumes the importance of philosophy of law with formidable rhetorical. He said, "From what serves to me knowing that the shadow of the trains, if I have no idea what is her destination and what station I will board?" It has been said that philosophy of law can dismember, and in an initial notion in number one, philosophical study of legal, number two, a philosophical study of the just. The first one, bounded with the juridical, it is the law at stricto sensu, okay? The second one, bounded with the just, it is justice. So the philosophy of law can assume that what is just and necessarily juridical, but the reciprocal is not truth. What is legal is not always fair. The bifurcation is temporary, but is quite reasonable. Before moving forward, I would recommend here a fantastic sequence of videos of Professor Tércio Sampaio Ferraz Jr., a video in Portuguese called Por que estudar filosofia do direito? In English is something like Why study philosophy of law? To move to this video, just click in our PDF in the hyperlink that I put it there, okay? I'm sorry for my slow English. I'm trying to getting better, and I hope you can just understand me for a while, okay? Bye bye.